afternoon, everyone. We are at 1:29. This is Mark Reinhard from Rehberg Law Group. We will probably wait another minute just to be absolutely on the dot and then get rolling. Thanks all very much for joining. We've got a few more people coming in, and so we'll let them in as they are more timely than all of us. Okay, well, we're now at 1:30 according to the tone. This is Mark Reinhardt from Rehberg Law Group. Thanks very much for making time out of what will soon be a holiday season to listen to me and talk together about care and feeding of a living trust. Couple things to let you know. Number one, I am in my office, so the sun has chosen this particular moment to shine, which means you're probably seeing my head haloed both because of the sunshine and also I don't have anything to stop that. So I may or may not actually take my photo off as we go into the slides down the road. And the other thing to know is you may hear some pings and things like that later because people are joining, or who knows, my phone will ring or something like that. Don't be alarmed. Finally, I think there's a window washer right outside who is desperate to get on screen. And so I think now and then he may be visible as well. We'll see if he has any questions. If you see a sign behind me that says help, then we know something's gone wrong, but you'll be the ones to let the authorities know that. So we're going to talk today about, do you know how to care for and feed your living trust? And I am told that these materials are available to you. They should be in the chat section. And you can see there, if you go to your chat button toward the top of the screen, then you should be able to say, have this care and feeding, and that will give you the PDF download of all the slides that we're going to be working through today. So that should cover that. I'm certainly hope come in and basically let me know that's not the case. So let's talk a little bit. We here at the firm do quite a bit of work with people one way or the other. Many people use a will, and we walk them through, this is how a will works, this is how it'll operate after you're gone, things along those lines. But we also help a lot of people put together revocable living trusts. And what I've found over the course of my 30 years plus as an attorney and 15 or so years here, that sometimes people don't really understand what a living trust is, and there's some common misconceptions that can lead people astray. So the bottom line is we want to make sure that for you, you have a better idea of what your trust is or how it works, or maybe you're just trust curious and want to find out, what is a trust? Do I need one, or would it help, or how exactly does it work? So let's dive in then. If that's the goal of this entire program, let's think about the overview of where we're going to go, all the different topics, all the things that it means to have a revocable living trust and how do they work. So as you can see, we're going to cover quite a few questions here. What's a trust? What are the different types of trusts? Who are the interested parties in a trust? What are the goals? Why would I even set up a revocable trust? How does a revocable living trust work? In other words, if it has certain goals, how does it achieve those goals? What's the magic? How does it actually work? Then we'll look at the funding part of it, and that's indeed a part of the magic of a trust, and that's titling assets in different ways to make your trust work correctly. Problems and hiccups with living trusts. This is when things not necessarily go wrong, but sometimes there's some miscommunication or misunderstandings out there, and the hope is we can clear up quite a few of them. And finally, big thing, this seminar may not cover everything that you want to know about. And if so, well, where can I get help, right? What if my question isn't answered? Now, it's possible that if you type in a message on chat, that I might be able to respond to it either during the seminar or shortly thereafter. But you should know if you do that, everyone else is going to see your name. So if you type in a message and say, Mark, my wife has become intolerable to me, or I'll murder my husband immediately after this meeting, know that all of us who are looking at the chat box are going to be knowing, hey, this is the person who said this. Therefore, we have a little bit of a problem. So you may want to be careful about that. If it's something private, email me or you're the other attorney with whom you're working here at the firm. So we've got a question already. Where's the PDF of the slides? You can go to the chat box. You have to click on your own screen and click on chat, and then you're going to see a welcome toward the top of that page. And there's a PDF that's a little bit scrolling down, and that'll have all the different slides we're going to talk about today. It looks like that's a common issue. So again, you got to click on your chat button on my screen. It's toward the top, and that should show a sidebar on the right. And once you find that sidebar, you're going to scroll down a little bit, and there is a welcome from Josh Humphreys, and you'll see a tiny little box that says care and feeding. And that box is the PDF of the seminars. So hopefully you're able to find that. Oh, yeah, good. Josh has also responded on that chat box. So if you can't find it at all, don't worry. Send an email later and we'll go ahead and email out the slides. So if you can't get it, it's not like they're going to disappear at the end of our seminar. Okay, well, let's then deal with that. And good luck, Josh. I'm going to leave it to you to figure out how to make sure that everybody knows where the PDF slides are. So let's keep rolling along. Make sure we use your time appropriately. And that is the first question we talked about. What is a trust? So many times I am meeting with clients, and of course, we're using words in an imprecise way, all of us, for ease of reference. And so we'll say, well, your trust owns this and your trust has that. But actually, a trust is not an entity. It's not like a company. It's not like a limited liability section. It's not, anything that has a separate identity except for the relationship between everyone. The relationship between everyone basically is what creates a trust. It is a legal relationship between three different persons or three parties, and that is the trustor, that's the person who created the trust. People that the trust is benefiting. Who's it for? What is the money, the accounts, the assets? Who are they going to be used for down the chain? So if that's the case, if a trust is actually not an entity, it's not like a company, it's more like a relationship, then we need to have a way to hold the assets and to title them. So we have to kind of draw things out. When I typically tell people, right, here's $1, right, here you go, here's $1. What we don't often think about is there's different strings of ownership that's attached to that money. And the different strings of ownership basically are who has the legal title to that asset. In other words, for, and that is equitable title. Who is this for? Those are the beneficiaries. So the trustee, for that reason, we're titling things usually, right? Trust assets, especially real estate. We're not just putting down the name of your trust on the asset. It's usually going to say something like the name of the trustees, John and Joan Doe in this instance, comma, trustees, the John and Joe Trust, UA DTD 1116 23. What that basically, the UADTD stands for is UA under agreement. A trust is an agreement, that legal relationship, and then DTT is dated. So you're putting those things down actually to show title. On almost all real estate, that's the kind of title they're going to be looking for. It would be the trustees on the legal title. Now, many times you'll have assets that aren't, you can't fit something that big into the name or the short little box that you get on the account registration. And but be aware the actual legal title and what people may be looking for is going to be that formal title. So the main takeaway on this is actually a trust. It's just a way of describing a legal relationship that the different parties to a trust enjoy or share. And that's why you may be a little frustrated sometimes with how things are titled, that most institutions or many institutions, and certainly real estate title companies, are going to want the full documentation of everything. I'm being told my voice is cutting out, but I am at 100, so all I can do is talk a little louder and hope that that yells a little bit. So that's the main idea on a trust. Let's then turn to the next page and deal with types of trusts. And we have more than one type of trust. And sometimes that can confuse people. They come in and they say, well, Mark, wait a minute. I have a problem here in that I don't know what type of trust is here. And so the revocable trusts are the things that are typically called revocable living trusts. These are the ones that are created for a specific purpose. When most of you put together your trust, it's going to be that revocable living trust. And these are, generally speaking, that's often called a living trust, generally the same thing. Revocable means, of course, you can change it or amend it, or if you want to, even revoke it. And the goals of that are pretty limited, and we'll look at that in a minute. Mostly it is to avoid probate, and it is to, make sure that we minimize any risk of guardianship. And we'll look at how it does that in a minute. However, we got to remember that a revocable living trust, when you after you've died. It also can be irrevocable if you become mentally incapacitated. The doctors say you're not able to handle things, your financial affairs, then it now becomes irrevocable. So revocable living trust can be changed, revoked, amended while you're living, but after you're dead or you're incapacitated, it becomes irrevocable. People can also then, create irrevocable trusts while they're living. So most of us will create a revocable living trust if we want to avoid probate, we want to minimize the risk of a guardianship. And the irrevocable trust, that's actually usually created for different reasons. Usually, if there's some kind of estate tax issue that they want to try to minimize their estate tax or make things pretty important point, and we're not really going to cover much about those types of trusts in this. We're really focused today on the trusts that probably most of you have, which is a revocable living trust. Finally, there's a third type of trust. Gets a little confusing, doesn't it? And that is called a testamentary trust. Testament means like after you're dead, through your testament, this testamentary trust is established. That could be through your will, A testamentary trust can be established after you're gone through your will, or it could also be through your living trust. After you're gone, your trust says, I want this to be distributed in trust to my spouse or to my wife, to my son, to my daughter. These things, right, are created trust. So when somebody, maybe you go online and somebody's touting how a trust can do this, that, and the other thing, then be careful. You got to try to make sure you understand which type of trust they are talking about. All right. We are still trying to work through some of the issues here on my feed is freezing up. I'm still not quite certain what to do about that other than try to tighten the cord here. And so I apologize. We may have to do the seminar again at some point if it just becomes, too difficult to hear what I'm saying. So we then need to look at not just the types of trusts, but maybe you also can deal with, and that is we have basically different parties to a trust. Tours in some people's documents. Sometimes they're called settlors. These are basically the people who created the trust. And in a revocable living trust, they can change it, they can amend it or revoke it, that kind of thing. Solve this problem, I'm happy if we go ahead and have you come in and plug, unplug, or someone suggesting shut the VPN off, which may be what we did last time. Here comes Josh to try to help out. Okay. The bottom line is because so many of you are having difficulties, we're going to stop and then restart. So we apologize for the difficulty. We've tried Teams, we've tried Zooms, we've tried a megaphone. So far, nothing is perfect. So bear with us. I'm going to stop sharing for a minute and we will try to reboot in as soon as we can. My apologies. All right. Well, hopefully, a lot of you are still there. Send us a message if you are, because heaven knows. All I know is this doesn't seem to happen to President Biden. I don't know what he does or, that's more important than what I do. But okay, I'm hearing that you're still here. And again, thank you for those chat notes. That was very helpful. What I'd like to do, since so many of you complained or at least informed me that the sound was cutting out, I'm going to try to just really briefly recap what we talked about up to the point where we shut down. So I apologize if this is a repeat. For those that could hear me perfectly, maybe go get an iced cold water, maybe, wander around the house, do some stretches, that kind of thing. So back to where we were. Do you know how to care for and feed your living trust? We looked at that slide. Basically, we were just introing it and then saying here were the different topics and subjects that we were going to cover that sometimes people have misunderstandings about. So you'll be able to see those different topics. Trust me, they're there. And again, if you can't find the PDF in the chat box, then we'll try to just email us and we'll go ahead and send you the PDFs after the seminar. All right, so the main point then is our first big question was what is a trust? What I was first describing is many of us feel or think that a trust is a legal entity like a company or a corporation or a partnership or that kind of thing. It's actually a relationship. A trust is a legal relationship between various parties, and we'll look at who these people are in a minute, but it's the trustor, the trustee, and the beneficiaries. Thank you. And so the bottom line is that think about like a family, right? A family is a relationship. So if you're going to make a check out to the family, you're not actually saying to the Reinhard family, although I'd probably try to go ahead and, cash that somehow. But the bottom line is you'd want to make it out to an individual. Why is that? A family is a relationship, but an individual is actually the title holder in that case. So the title holder, the legal title of a trust, is actually the person who's named as the trustee. They have legal title. When you have a bank account, you don't usually think about this, but you open up your bank account and your name is on the account. So you have legal title. You also have the benefit of the money in that account. So you have also what's called equitable title. The money is yours to control, and the money is also there for you. But you can actually separate those strands of ownership, and a trust does that. A trust says one person has legal title, that's the trustee, but other people have the equitable or beneficial title. Those are the beneficiaries, the persons or entities for whom this trust is being managed. The trustee is acting on their behalf. And this weird distinction between legal title and the way we normally think of someone who owns money or a company, that's why we have this odd way typically of describing how to title things. And so the titling is often you'll see, especially on a deed, a quitclaim deed, if you've done that, you'll see something like your names, trustees, John and Joan Doe, trustees, comma, under the John and Joan Trust. And then it says UA, DTD, typically 11/16/23. What the heck, UA? That's actually not for United Artists. It's for under agreement, and DTD is dated. So this means, right, if someone is titling it now, John and Joan have legal title to the assets in the John and Joan Trust under this agreement that's dated a particular date. They are managing those assets on behalf of the beneficiaries of the trust. So, main takeaway, a trust is a legal relationship. All you really need to know is that's a little odd, right? But it is explaining to you why sometimes people will want you to name the trustees in the actual title of various accounts. Oftentimes there's not enough room, especially if you're just using a kind of a fill in the box form or something like that online. But oftentimes, especially in legal deeds, this does make a difference. Okay, so we need to then refresh our memories, and forgive me again if this was the part that I was being heard, but we should at least think about the different types of trusts. And they are legion. The different types of trusts. Number one is a revocable living trust. Revocable, of course, means that you can change and amend it, or, that kind of thing. You being the creators, the trustors. These are largely created. The goal for a revocable trust is largely to avoid probate. That we'll look at how it works during this seminar, but the bottom line is that's what it's mainly for. It also has the advantage of minimizing what guardianship risks there may be down the road. So this revocable living trust, it has specific goals: probate avoidance, minimization of a guardianship proceeding risk. It does, however, we need to think about this, it becomes irrevocable when you die. Why is that? Well, because it's very hard for a dead person to change anything, right? They can't reach up out of the grave and sign amendment number 1 to their trust. So once you're dead, typically the trust becomes irrevocable. For married couples, there's a bit more nuances here that you want to talk with about your attorney. And also, then you want to make sure that, you also understand your trust may become irrevocable on incapacity. If for some reason you are, mentally incapacitated, Alzheimer's, dementia, that kind of thing, then there's also another reason why the trust would become irrevocable. A incapacitated creator, the trustor, is not able to change legally their trust. Now, some trusts are created irrevocable, right? They don't just wait for a revocable trust to become irrevocable on death. but instead they're created to be irrevocable from the very beginning. Those trusts, those types of trusts, generally speaking, are created for asset or estate and gift tax efficiency or asset protection. The idea is you take an asset that's in your name under your control, then you put it in this irrevocable trust that's no longer possessed, or you don't get income, you don't get to enjoy it or control it. And you're doing that for estate gift tax purposes. You also might be doing that for asset protection purposes. Finally, there are so-called testamentary trusts. Testamentary means you testament. You're doing this after you've died. Your testament says some portion of the money that you're leaving to people, some of the assets aren't going to them directly. Instead, they're going to be held in a trust for their benefit. A testamentary trust, as you can imagine, is also irrevocable since you're dead. That's the testament idea. And, it's not created typically till after you're gone. A testamentary trust, incidentally, can be created in a will. Your will says this portion I give to people in trust, and that's when a testamentary trust is created. Of course, it could also be created through your revocable living trust. All right, the interested parties in a trust. I think this is about where we rebooted and the new and improved version of this seminar was put into play. Something like I keep hoping will happen to the Chicago Cubs every year. They'll get a new and improved version. The interested party in a living trust are basically three general groups of people. Number one are the trustors. You may remember we mentioned them before. The trustors sometimes have different names depending on the document you're using or what the attorney likes to call them. Sometimes people will call them grantors or settlors. Basically, these are the creators. These are the people who established this revocable trust. Well, they established it, therefore, they can change it, amend it, or revoke the trust. There are people who are called trustees, and I mentioned those before. These are generally the people that are managing the assets in the trust, and they're managing those on behalf of others. Now, while you're in charge of your own trust, you're managing it, of course, for yourself. But once you can't do it or down the line there's an issue, the trustee is managing it on behalf of the beneficiaries. It's important that you know a trustee is a fiduciary. This was, think about Semper Fi or Fido. Fiduciary is a fancy word for you are acting faithfully for other people. Your revocable living trusts while you're living, that is going to be your money. There aren't a whole lot of duties involved while you're still in charge of your trust. But once you die, or if you become incapacitated, whoever's serving as the trustee, they aren't using the money for their own benefit to go buy their, new Camaro or to buy this summer home for themselves. They're using the money in the trust for the benefit of you or the people that you set out in the trust. The trustees actually owe duties. This isn't just sort of a, hey, here you go, do what you want with it. I hope you'll do right. But there are legal duties that a trustee owes to the beneficiary. Generally speaking, you can group these into three. That's the duty of impartiality. That means, if someone else is serving as trustee, they're not the grantor, they're not the beneficiary. They're acting impartially for the benefit of other people. So imagine you have your two sons and, Grayson and Mark, they are both, your son's Grayson becomes the trustee. Well, he can't use the money just for his own benefit, right? He's got to act impartially among all the beneficiaries. There's a duty of loyalty, and that is that whoever's serving as trustee, they're putting the interests of the beneficiary first. And finally, once a trust becomes irrevocable, there's a duty to account. In other words, if somebody asks what's going on with the trust, what are you using the money for? Of course, they have that ability to find out. Don't worry. These are duties that the trustee would have if you became incapacitated for yourself. They owe you these duties. Once you're deceased, the trustee will owe these duties to the beneficiaries. But while you've created your own living trust, which I know many of you on this webinar will, that's the case, you're not really owing a whole lot of duties, if any, to anyone else. Now, there's also the beneficiaries, just so you know, right? There's the current beneficiary, that's who gets, the benefit of the money now. And there can be also contingent beneficiaries when that person you've named, the current lifetime beneficiary, when they die, where does the money go next? Who gets it next? And actually, the trustee, once a trust becomes irrevocable, they owe a duty to both current beneficiaries and to the beneficiaries down the road. So if you named it, it all goes to my son in trust, but when he dies, it goes to the March of Dimes. The trustee has to keep in mind this irrevocable trust. They owe duties to both, to maybe account and not squander the money, etc. So the interested parties in a living trust. Now, I already talked a little bit about what the goals of the living trust are, but it's important that we know what they are. For a revocable living trust, the goals are pretty focused. Sometimes I'll meet with people and they'll say, Mark, I need a trust. And I'll say, why? And they'll say, well, I've heard a trust will help me avoid estate tax. And the answer is that is not what a revocable living trust really primarily does. It can have language in it that helps you do that, just like a will can, but a living trust won't give you any additional advantage to avoid estate tax. Why? Because you're completely in control of the revocable living trust, so the IRS ignores it. They say, look, if you're completely in control of an asset, when you die, it's part of your taxable estate. So that's not a goal. Sometimes people come to me and they say, Mark, I want a trust. And I say, why? And they say, well, I'm worried about the cost of assisted living down the road. I want to make sure I can qualify for Medicaid. And I've heard these advertisements on TV or the radio. And the answer is, a living trust isn't that kind of trust. That's a Medicaid or special supplemental needs trust. There's safe harbor trust. That kind of trust is a different type of trust than a revocable living trust, because here too, Apple Care or whoever the DSHS, whoever is overseeing Medicaid payments for assisted living, they aren't going to pay any attention to the fact that there's a trust if it's a revocable living trust. Why? Because you're completely in charge of it. You can do anything you want with the money. So this living trust will not help you avoid, do any kind of Medicaid planning. That's a different type of trust. And finally, sometimes people go, Mark, I need a trust. And I say, why? And they say, well, I really want to make sure that my house is protected in case I'm sued. And here too, the living trust isn't going to help with that because again, it's revocable, changeable, amendable. You're in complete charge of it. And the creditor, the judge, is going to say, yeah, this kind of trust isn't going to help you. Those are different types of trusts than a living trust. Well, oh, wow, that's a lot that a living trust doesn't do. Why does anyone get one? Well, they still have some pretty good advantages. Number one, their goal is to avoid a probate after you pass away. And we will look at how it does that in the next slide. The second thing they do is they will help to minimize the risk that there might be a court process, a court hearing, a judicial, hearing, or even a legal guardianship if something happens to you while you're living. And we're going to look at how it does those things in a minute, but we need to understand the goals of a living trust. Pretty focused. Generally speaking, avoid probate after you're gone, minimize the risk of a court proceeding or guardianship if you become incapacitated while you are still around. Well, how does it do that? How does a trust, in any way make this happen? The basic idea we need to think about is the problem is when assets or accounts are left in your name. If you have an asset or an account in your name, then we have to think about, okay, Your executor goes after you've died and they hand your will over to the bank or the title company or the financial institution. They say, "Oh, bad news. I'm really sorry, but that your dad died or your spouse passed away, and we see you brought the will in." And you're thinking, "Well, of course I brought the will in. It says I'm in charge. Here you go." And you hand the will over. And that bank, the financial institution, the title company, they're going to say, "We're very sorry, but we don't know if that will is valid. Does it follow Washington law? That's not our job to figure that out. We don't know if this the most recent will. Maybe there's another will that revoked this will entirely. And also, we don't even know if this is fraud." They had some cases in Washington a few years back where people weren't even dead, and the people were taking money over and claiming they were. So the bottom line is those banks, financial institutions, the title company, they're going to tell your executor, "I'm very sorry. This may or may not be the right will, but your executor, you have to go to probate court and get what are called letters testamentary. These are the magic pieces of paper that they need. They can get those letters testamentary and bring them to the bank, the title company, and it's going to say, it's one-page piece of paper. It's going to say, this is who the executor is. They've been appointed by a court. That will give that institution the comfort to work with your executor. So with a will, ironically, there will be a probate. Now, if you die without a will, that's a probate too. And in fact, it's quite a messy probate because you haven't set out any of the terms. But even with a will, there will be a probate because a will doesn't change title on anything while you're living. It's designed to help your court-appointed executor change title to things through the court process after you're dead. So that will mean a probate. And a lot of us have the misconception, "Well, I thought I got a will because it wouldn't lead to probate." I just met with clients this morning that thought that. The answer is, unfortunately, that's not true. That's a myth. A will, if you use it, the only way it springs to life and becomes effective and will be honored is if a court says it's the right will. So that means a probate court process. The other thing is then, if you become incapacitated, your will doesn't do anything for you, of course. You're still alive. You're not dead yet, as Monty Python would say. So now what? Well, you'd have to depend upon other documents. And those other documents are a power of attorney generally, but a lot of institutions are very frightened and timid in accepting a power of attorney. And if they don't follow that institution's policies completely and perfectly, they will not honor it. And if they don't honor it, now what? You're living, your son, your daughter, someone else needs to get control of the assets. They can't. So that institution that said, "No, we won't honor this," they're going to say, "Well, go get a court order," right? We'll honor it if there's a court order. Well, that leads to time, delay, and expense. And of course, the worst case scenario is an actual legal guardianship would need to be started over the survivor. That is a very involved court process. It can cost tens of thousands. And every year you have to go back to court and do a report on what's going on. So it's a long-term commitment. And that's a slight risk if you have a will, because a will doesn't change title to anything. Now, okay, well, how does the trust work then? How does it avoid this? The question is often, will a trust avoid probate if in the back somewhere you put in on Schedule A, I've listed out all the assets. There were these trust mill companies that would go and rent out a motel or hotel convention hall, and everybody would start a trust of the 150 people who attended, and they would just write down what assets they meant to go in the trust. They sign it, they date it, they die. Will that help avoid a probate? And the answer is, unfortunately, of course not. No. The assets have to be properly titled with the bank, with the financial institution and the county recorder. What these people had done is they just put a list together, sometimes literally in pencil, because they knew their accounts were going to change from time to time. You can't bring that list in. The institution is going to say, I'm sorry, you need the magic pieces of paper called letters testamentary to, in order to get these assets, get control of them, and even get them into the trust. So proper titling is a big deal with a trust. Simply having the 50-page document by itself won't actually solve a whole lot. It is going to be important that you title things properly. And okay, so I've got a comment here that's someone that the bank or other businesses, they wanted a copy of the will in addition to the letters testamentary. Thank you. That's helpful. You know, it just depends on the institution itself. So thank you very much for sending along that word. Each institution will have its own, like, this is what we're demanding, this is what we're calling when there is a probate and they're asking for those letters. Sometimes they'll also, of course, ask for a tax ID in a probate, but that's another seminar entirely. So anyway, how does a trust work? It works because you've titled assets appropriately. Okay, let's just kind of pound into that a little bit, because this is one of the main issues that people often have with trusts. We need to make sure that everything is titled appropriately. What ended up causing the probate or the guardianship? Answer, your name was left on an account, your personal name, not, John and Jane Doe, trustees of the John and Jane Doe Trust under agreement dated, your name was on something. Now, that means we got to look at titling, the funding issue. And basically, there are a couple choices. Don't worry, we're going to get into this. But the bottom line is either your assets need to be retitled to be putting them into the name of your trust. This is when you've got a revocable living trust, or you have beneficiaries on them. The idea is when you die, your, the executor, the trustee, the person in charge, they are going to be either reaching out to the bank or the IRA institution. Here's who the beneficiary is. Please, give me the paperwork, and they can fill that out. So those assets aren't left in your name because there was a beneficiary designation, or it's titled into the name of your trust. And then when you die, your trust owns that asset. They either, many times it's a beneficiary designation to the trust, or it was already titled into the name of the trust. And the bottom line is then you can create the magic pieces of paper. These are certificates of trust outside of court. We can do that here in the office. We put together the appropriate wording and have those certified and notarized. Usually, almost always, that institution is going to look at the certificate of trust that you're next in line, the trustee who serves after you. Then they're going to say, oh, okay, what do you need to do? And that way, your executor, essentially in this case, your trustee, they are going to be able to get control of the assets that you have without having to go through probate. And the nice thing too is they can also then get control of the assets if they need to. Your trust will say, at least if it's one of our trusts, it's going to say, in section 3, it'll say, if I become incapacitated, right, and here's how to prove that. Usually 2 doctors or, a healthcare provider, a geriatric care manager, they say you're not able to handle things anymore. Then in coordination with the trust paragraph under paragraph 6.1, at least of our trusts, it's going to say, here's who's the next trustee is. They're the trustee, but you're still living. They can take over the accounts with the pieces of paper they can get outside of court, and then they can also manage those accounts going forward on your behalf. So the magic or the funding of titling, the titling issues, very, very important. Not funding your trust is clearly the wrong approach. Now, what'll sometimes happen is we'll come and we'll meet with people. We'll say, hey, would you please provide us with your account statements and your asset information so that we can title things appropriately? And they give us, their house deed, and they give us some accounts. But for whatever reason, they didn't give us a number of different assets. Or what happens is then that bank, they decide they're going to move their money to another bank with a better interest rate, and they don't tell the new bank about the trust. Oops, now they died. The trust isn't on that account. Now what do we do? Well, unfortunately, there will be then something that has to be done. Often, if there's enough assets outside of your trust that don't have a beneficiary designation, they're just stuck in your name after you've died, then you may have noticed in your binder, you have a tab in your binder that has a will section, and the will is actually still there with a living trust because it's called a pour over will. It's needed so that just in case something didn't get properly titled into the name of the trust, then we have a way to get it in. So not funding your living trust is a problem. Now and then I have clients and we, for lack of a better wording, will nag them a while. Please, please, please come in. But obviously we can't force anybody to do something they just don't want to do or don't have time to do. They have a trust. The trust will work, but it won't work to avoid probate because we're going to have to use that pour over will. Think about picking a cup up and pouring it over into another glass. That's essentially what a pour over will does. It says pick up and pour those assets into the trust. That's going to require, in many cases, a probate. So not the ideal situation. Okay, so now we know why it's so important. Now, I have a complicated slide here. You may or may not be able to read this. So if you can't get the PDF, now's the time to remember to shout out to Joshua. The poor person has, volunteered to send PDFs to people. When I go through this with my clients, it's very difficult to kind of see the big picture. And I'll often talk to them about what I call the 3 buckets of funding a trust. The idea is we want to maintain the tax advantaged accounts. These are typically retirement accounts like an IRA, a 401k, 403b, etc. Tax advantaged, often known as a qualified account. We want to keep those tax advantages. The second kind of bucket are just things that would make it easy for you in life. I call that a convenient bucket. And other things we put into the name of the trust. It's important that I warn you, these are general guidelines, right? There may be reasons why you're not doing this exactly, or your attorney told you differently. But the general guidelines will work probably about 80 to 90% of the time. So your retirement accounts, right? The IRAs, the 401ks, those for usual purposes, obviously you're not going to put those into the name of your trust. If you did that, that's a taxable withdrawal. So don't take an IRA out and put it in the name of your trust. That's a big oops. Don't do that. You may be tempted, right, to say, I want my IRA, the beneficiary, to be my trust. I'd like you to not do that unless there's some particular major issue. Somebody's in the middle of a divorce, one of your kids, or they can't handle money, they've got a drug problem, they're special needs, something like that. But otherwise, put individuals down in usual cases, because individuals are considered qualified beneficiaries. And qualified beneficiaries get generally tax advantages just like you did. They may not get them as long. For most of us, we're going to get a lifetime stretch on our 401ks or IRAs. We have to take the money out at, 72 or 73, whatever the year we need to take it out. But for our beneficiaries, they're typically going to have what's called a 10-year stretch, a 10-year period to take it out. But that's better than the risk of having the money have to come out even quicker. So if you name your trust, that's all you said, my living trust, or the, John and Jane Doe trust, it's possible that they'll have to take the money out in 5 years. That leads to a higher progressive tax rate. Or worst case, actually, they have to take it out immediately, which would mean a huge tax hit this is after you've gone, of course. So the general rule for retirement accounts, generally speaking, leave it in your name. Make sure you got beneficiaries. And unless there's a problem with somebody, individuals are generally best. Primary to spouse, contingent to kids, something like that. There's also what I call a convenient or easy bucket. And that is where it would just be a pain in the rear end to try to change how things are titled while you're living. The first thing that'd be a pain is if it's a mortgaged property, mortgaged real property, not your own home, but maybe you've got a rental, maybe you've got a second house, maybe a retirement place you bought in Arizona, but it's got a mortgage on it. Generally, you don't want to put those in a trust because the lender could get a little upset and say you've breached the due on sale or due on transfer clause. So there's another way we would leave those in your name, but you'll see this TOD. That's short for transfer on death. Many states will allow a transfer on death deed. We would keep it in your name now. When you die, that's when we say put it into the trust. Why? Because the mortgage is going to have to be dealt with at that point anyway. You're not around to pay the mortgage. So we can get it into the trust that way with a minimum of fuss and bother while still leaving it in your names while you're living. Small bank accounts, the things you use day to day, maybe your electronic payments in, maybe you're making payments out, or you're getting Social Security, or you just don't want to change the checkbook to say John and Joan Doe, trustees of the John and Joan Doe Trust, et cetera. You just want to keep it in your names. That's okay. But you want to make sure that you added the trust as the beneficiary on the account. Most banks, most institutions will allow you to do this. There's a few that won't. They're typically online institutions, but most will allow you to do it. You're saying, keep it in our names. When one of us is gone, right, then, right, joint with right of survivorship, when we're both gone, this is if you're married, then the beneficiary is your trust. So here too, that account goes into the trust after you've died at just the right time, and we don't have to worry about a probate for it. Vehicles, unless they're really spendy, like a really great RV or a fantastic car, a Rolls, a Bentley, a top of the line Mercedes or something, if they're just a normal, modest value car, you don't need to worry about putting those into your trust. It's pretty easy to transfer those after someone has passed. And finally, then let me go back. I pushed the wrong button. Life insurance, right? You're generally speaking just making sure that the trust is the beneficiary. So we've talked about retirement accounts. We've talked about what I call the easy bucket, the convenient bucket, right? And then finally, most other things are going to go into your trust. That would mean your own primary residence. If you have other unmortgaged real property, things that you have that don't have a loan on them, you have non-qualified accounts like, investment, brokerage, stocks, mutual funds, things like that. Maybe your larger bank accounts that you're not using day to day, you could put those into the trust. You'll notice then that between these buckets, there is no bucket for things that are left in your name after you die. One way or another, it either has a beneficiary designation to a person, it has a beneficiary designation to the trust, or it is already titled into the name of the trust. These are absolutely key. That's how we end up avoiding the probate issues after there might be some problem down the road or you pass away. What'll often happen is, okay, I've got a question. Does a property that is in an LLC go into the last bucket? Great question. An LLC owns the property. The LLC itself, the limited liability company, that should be owned by your trust. And this is, of course, if it's a sole owned, you're the only owner of the LLC. So the LLC, right, is still there, but instead of you owning the LLC, the trust owns the LLC. And the LLC still owns that underlying house or rental property. So you're not changing the deed with that. what you're essentially doing is changing the ownership of the limited liability company. And that can be done through a consent. That could be done through, changing the exhibit, the ownership exhibit on it. You'll want to make sure. Again, this is if it's only owned by you. If there's multiple owners, you'd actually have to look at the operating agreement. This is the constitution, the agreement between the owners, and make sure that's okay to do. Thank you very much. Great question. Okay, so let's look at then what I'm going to call the problems and hiccups of a living trust. Now, living trusts are great, great tools, right? They're going to help avoid a mess. Of course, a will does that too. Good written documents will help avoid a mess. They're going to say, here's where things go, here's how it goes to people, and make sure as much goes as smoothly as possible. A living trust, the additional benefits, of course, are that probate avoidance and minimization of the risk of a guardianship. But what can possibly go wrong with that? You're doing the best you can. There are often a few hiccups or problems that can arise. Number one, we already talked a little bit about this. If you've got a mortgaged property and it's not your principal residence, if it's your primary residence, you can transfer it to a living trust. This is an exception. A lender is not able to call the loan due. It's under the Garn-St. Germain Act. There's an actual exception. People can transfer their primary residence, even with a mortgage, to the living trust. The mortgage itself, I should mention, doesn't get transferred to the living trust. That stays in your name. Lucky you. As well as other debts. Most other debts that you owe are just going to stay in your name. But what we're talking about then is those secondary residences or the rentals or other investment properties. If they've got a mortgage on them, you cannot or should not just transfer it blithely or blindly into the name of your trust, because you may have accidentally violated the due on transfer clause in the loan. The bank could say you're in breach and therefore we're, going to ask for all the money now. It's pretty unlikely they'll actually do this, but they can find out. Many times there are audits done, not only by the bank itself, but by the FDIC. And those inspectors, those auditors will come in and look at everything to make sure the bank is acting properly. And if they find out, well, wait a minute, Mammoth State Bank Savings and Loan, did you know? And then that bank is going to act and act quickly. So be careful about that. Remember, for most states, Washington State especially, we have another way to title those accounts: transfer on death deed, which leaves the property in your name, but then when you die, then it gets transferred into the trust. That way we don't violate the mortgage. And in fact, at that point, of course, if you're dead, someone's going to need to handle how to handle the mortgage anyway. There is sometimes what happens when people have their own home into the trust and it was fine to put it in, but they decide they want to refinance or they want a home equity loan. Not as much now because the interest rates are a lot higher than maybe when you got that loan originally. But what will often happen is that bank or institution is going to say, you know what? We have underwriting, requirements and rules. We'll give you a lower interest rate if the house is in your name. So they're going to literally ask you or pressure you, insist that you take the property out of the trust. And there's a deed from your trust back to you as individual owners. Then you get the refinance or the home equity line of credit. And then after you get it, they'll say, okay, now go ahead and put it back in. The hiccup is they're not going to pay to do that. So you either need to do that or engage your friendly neighborhood attorneys to help you do that. But that is something that some banks will do. For some people who are looking for the senior exemption on their property taxes, the living trust, there's a bit more paperwork you might need to fill out. If you are worried about this, I've got the number here. It's Form 640085. That's here in in Washington, 640085. It's Declaration of Trust Property Tax Exemption for Senior Citizens and People with Disabilities. And so you need to fill that out because otherwise they don't know like who owns it. So instead of your name, it's the trust name. You have to fill out some additional paperwork to make sure if you're getting that senior exemption on property taxes or discounting, that's still available. Of course, if you later on decide you are going to need Medicaid planning, the testamentary supplemental needs trust, with you have a spouse especially, is going to be something that you'd want to look into. The problem is that's considered under Washington state rules only available through a will. So many times for Medicaid planning, remember Medicaid is for people who need financial assistance for two or more needs of daily living. It's for basically indigent people. And the living trust will have to be defunded in order to do the things that need to be done to give things out or to move things around in order to qualify for Medicaid. I was talking with someone a few days ago, and they may need Medicaid in the future. And I said, you know what? We don't want to do a trust. They really, really wanted to avoid probate. They were somewhat concerned about guardianship, but it was more likely they might need to qualify for Medicaid at some point in the future. The issue is don't pay the money to put together a living trust, fund everything, retitle everything, and then 2, 3 years later, you find out you have to defund the trust and put it all back into your name in order to move steps forward on that. We talked about the failure, to fund assets. And then the main thing is you are just got to make sure. I compare a trust more like to a pet. Your will is a stuffed animal. You sign your will, you put it on a shelf, it collects dust, and you hope it collects dust for a long time. But your trust, actually, you got to pay a little more attention to it. If you are getting new accounts, new assets, even if the institution you're working with merges with another company and they take over all your accounts, you got to go back in and make triple sure that the titling with the new company has carried over and is appropriate. So if you don't do that and things are left in your name, we learned what can happen. Even with a living trust, there probably will be a probate. So the next little bullet point here is a point that sometimes it seems obvious, but I can see there's an idea that, great, I've got a trust, I don't need to worry about anything. Well, obviously, you got to coordinate with the bank and the financial institutions, etc. Just because you have a trust in a notebook sitting somewhere won't do a thing for you. You've got to make sure that they know about the trust, that they have the information they're comfortable with and they're required. Maybe they want the trust title. Maybe they want a certificate of trust. A few might actually ask for the entire copy of the trust. Many times those banks or financial institutions will ask a question, which stumps a lot of people, and they're going to say, oh, I see, you've got a trust. And this is your revocable living trust. And they say, what's the tax ID for the trust? What? What tax ID? What are you talking about? When you're living and it's your revocable living trust, that is your social security number. So they don't know. Remember, we talked about irrevocable trusts before and testamentary trust. Those have a separate tax ID. Your revocable living trust has your social security number. Sometimes I meet with people and we send them out the drafts and they're actually a little upset. They're not upset because the draft doesn't do what they want, but they're upset because we sent a will. Why did you send me a will? I said I wanted a trust. Well, we sent you both. You have your living trust, but remember, we have that backup called a pour over will that just in case you left something out, it says pick it up and pour it over into your trust after you're gone. We don't want to use that. That's like an airbag in your car. Yeah, we don't want to use the airbag. but we're very thankful if it's there if we need it. It will help avoid a real mess. So there's confusion about that. Remember, your pour over will is not your primary vehicle. That would be your living trust. The pour over will is just there to make sure we avoid a mess if by some reason you forgot to title something appropriately. And finally, one other hiccup that can sometimes happen is I will talk to someone, maybe a child, and they say, Mark, I went down to the bank. Mom sent me there. I'm trying to use the power of attorney, and the bank says I can't use it. Why? Why can't I use it? The power of attorney, that is a separate legal document, typically called a durable power or a power of attorney for financial assets. Those are for the assets that are in your name, not for things that are in the trust. So I'm going to skip back a page. If we've done this right, what's left in your name even with a trust? Well, your retirement accounts, those are in your name. The power of attorney would work for those. Probably the smaller bank accounts, those you remember you put in your name for now, but you have beneficiary designations. Your life insurance, probably, right? You've got that in your name. And possibly if you have second properties that have a mortgage, those might be in your name too. But a power of attorney won't work for the things in a living trust. The living trust will say, who serves next if you can't? And that is your often known as a successor trustee. They succeed to you, like you think about royalty, one king, like Prince Charles becomes king. He has succeeded. He's the successor to his mother, Queen Elizabeth, and now he's King Charles. So that's the same idea. So sometimes people get confused. Each document, power of attorney, works for those assets that are in your name. The living trust itself works for the assets that are in the trust name. So those tend to be most of the problems or hiccups I see. I'll be honest. This is probably the reason I wanted to do this seminar. I don't see a lot of you coming to me and going, oh, I want to change things based on the seminar. But I wanted to provide information to you on some of these very common misunderstandings or misconceptions, or just so much information is given to you, it's very difficult to keep it straight. So if I were you now, I would have listened to this talking head in a small corner of the screen, and I would have gone, well, that's great information, Mark, but how in God's name am I supposed to remember all this? I'm going to get off this seminar, and in a half an hour, I'm going to forget 90% of what you said. Well, hopefully the slides will help, but I have also put down a few resources where you can actually get help on your own. Your trust notebook. If you work with us, you should have one of these. So the bottom line is, right, your trust notebook will be your first source of defense. And there's a couple places you can look to. Number one is called a Living Trust Handbook. This is near the beginning, and you can look through here. It's going to describe what a trust is. It's going to say, here's what your will does. Here's why a trust is put together and how it works. That's a great place. Another one for titling purposes typically is almost toward the very end. If you've done a trust with us maybe in the last 10 years, it's just got a kind of a bland name. It's called memorandum. And in this memorandum on about page 4 or 5, there's going to be an exhibit or an appendix A, and that will talk about types of property and general rules on how to title them. Once again, general rules, but these usually, for when we've done this for you, it'll actually have your trust name there. So it's going to say, hey, for a real estate property, here's generally how you want to title it. And in bold or all caps, it's going to say, here's how you're going to want to title that piece of property. Or a bank account, what do I do? So those are some great resources for most of you, you already have. You can also go to our website. There's a section on that called resources and videos. If you want to subject yourself to those, there's a lot more information there. Or of course, you can reach out to one of us. If you work with Ryan or me or Sabrina, any of us here at the firm, you can go ahead and reach out to us and say, hey, I need a meeting or I got a quick question. So there's a question for us, and we're going to start. If you do have questions, now is probably the time to ping those out, put them in the chat button. I got a question here. So assets go to the pour over will. Then after the trustee died, will this become probatable? The answer is yeah, if there's assets that are in your name or in the trustee's name after they've died, then generally speaking, they're probably going to need a probate. There are rules that, if it's under 100,000 in value, they might not have to do a probate, or maybe there's a community property agreement between you and a deceased spouse. Maybe they don't have to. But generally, most of the time, when assets are in your name, we need to use the probate pro over will. That is a probate. When you use a will, you will do a probate. You mentioned that some of our videos are getting a little older now. Are they still current? To my knowledge, we've left ones on that are still pretty good. There may be some numbers on taxes or things like that. The exemptions go up or down depending upon the whims of the legislature. So those you'd want to take with a grain of salt. And we do seminars a lot. We also have constant contact that you can sign up for if you aren't already. And those will, generally speaking, provide you with new information that you can, look up from time to time. Oh, I see that video said this. Mark had hair then. Is that still the truth? How old is that? Then you can, see those constant contact videos or sign up for one of our new seminars. And that'll give you the more updated information. I regret very much that even though it would make all of our lives a lot easier, and even though I probably wouldn't be as busy, I regret to tell you the legislature constantly is at work. In fact, there was an old judge from the Tammany Hall era. Tammany Hall, as many of you may know, was a period in New York that was run by a very corrupt and crooked political, mob, essentially. And so the bottom line is, this judge at that time said, anytime the legislature is in session, your money, your liberty, and your property are never safe, right? So that was actually in a court opinion, and there is some truth to that. Okay, can you talk for a minute about how to choose who to manage on death, entity or person? Yes. Basically, you are looking to people, and I'm, going to give you an acronym to help remember it. You want people who have T for time. If somebody in your world, they've got time to do what you're asking them to do, because this is going to take a bit of time, whether they're the trustee or an executor. You want someone, of course, who's honest. That makes sense, right? So time and honesty. You want them to be organized. If you go to their house and their paperwork scattered all over the floor, or they, have their tax return has got peanut butter and gum on it, or their dog is eating it in the corner, probably not the right person, because they're going to have to keep all of this organized and separate from their own taxes. And so you need that to be very careful. And then finally, of course, you want them to be responsible. If you give them this job, will they take it and do a good job? Most of the time, you're able to find people in your world that can do that, whether it's family member or friend or acquaintance or business associate. But many times we can't. And if we can't, then there are a number of banks or trust companies or even law firms who will serve as executor or trustee after you're gone. The negative with those, of course, is they will charge more when they serve. Typically, it's a percentage of assets under management, and that is an annual fee. So they may charge, for the first million that they're managing, they may charge 1%. That might be $10,000 a year. And usually an individual is not going to be charging anywhere close to that amount. So you're usually looking to individuals first. If you don't have people, or you feel like this is administratively difficult, or you have family that might fight For example, you know your son needs a trust because he's in a really bad relationship, but you don't want to put your daughter as trustee over her brother's trust and ever have to say no. You might end up having to pick an institution. If it's a special needs trust for someone who's on Medicaid or government benefit, those are pretty complicated. You might choose an institution. If you have only family members who live overseas, not in the US, you also may need to choose someone here because it's really putting people in a difficult spot to have an out-of-country trustee. There can be a lot more tax withholding. There can be additional reports, and failure to file those reports can lead to thousands of dollars of penalties. So almost always you want an in United States resident who you're looking to. Okay, what is the basic? Oh, I mentioned acronyms. So time, honesty, organized, responsible, Thor. You want a superhero to serve, THOR. What is the basic process for transferring your home to a living trust? The basic process is you need to get a copy of whatever the current deed is. Then typically you'll need a transfer deed to your trust. That can be in the form of a warranty deed or a quitclaim deed. Our firm, we do quitclaim deeds when we transfer property into a trust, real property. And that is basically going to be under the statute. Here's how it looks. Here's the grantor, which is you. And then your trust would be the grantee. That's who's getting the property. And you're not only doing the quitclaim deed, you have to file it, of course, with the county. And with that filing, you need to have what's called a real estate excise tax affidavit. That real estate excise tax affidavit, or here's another acronym, RETA for short. RETA form must be filled out if you want to avoid excise taxes. You need to let the county know this is not a sale. I didn't sell my house to this trust. I am really the same person on either side. And there is a very specific Washington Administrative Code exemption for excise taxes under those circumstances. So you'll want to have that RETA form and the quitclaim deed. Those will get filed with the county and recorded. That's the basic process. Obviously, the gotchas are don't do this if you have mortgaged real property that is a second non-primary residence. And just make sure, right, that there aren't any other odd issues going on. But that's the basics. All right. Well, good work to all of you. Let's see. It looks like, at least at the moment, you don't have any additional questions. Remember, if you don't have the PDF at this point, I'm pretending that Josh is going to try to get that to you, but you can email us here. Hey, I really would want a copy of the PDF. Maybe take a few minutes of your own time. Go back to your binder. I always think it's a good idea. When I meet with my clients, I'll literally put little sticky notes and tabbed on certain sections of the binder. And the idea is, remember, the binder isn't just information, but you can provide information to your next in line as well. So, there was a question about who can serve as a trustee. Boy, it would help that successor trustee if you let them know where the assets are, how things are titled, who are the people to contact if something happens. In your binder, there are blank pages that allow you to fill that out. So I'd encourage you to do that as well. Now remember, like any seminar, I need to warn you, this is general advice. So don't immediately go out and go, oh, I know everything there is to know. This is to give you general guidance. If you have specific questions, of course, that's every situation basically is specific. So you want to make sure you get that advice. And hey, where would you do that? Well, you could do it with us. That'd be nice. You could request a consultation, right? If maybe a checkup, maybe, hey, I just want to go through and talk about who the heck am I going to get to be my trustee or executor or agent, or I do want to look more into who would serve as a fiduciary, that kind of thing. We want to be a resource to you. Frankly, that is the purpose of these seminars, to make sure you feel like from time to time you're getting good information from us. So I am going to leave this open for a few minutes, even though I'm going to probably leave this. Hopefully Josh will stay on it. I'm going to close down on mic and camera, but if you do have questions, we'll probably leave this open a little bit of time in case there's something that you have a question on. We'll try to get back to you. Thanks so much for attending. I appreciate it. I hope everybody has a great Thanksgiving and being with family or friends or just having a great time. What beautiful weather we're having, and I hope that continues as well, especially when I'm traveling next week. So take care, all of you, and we'll see you soon. All right, bye-bye.